Very good morning to all the participants from 23 national law universities and the professional institutes. On this 11th day of the master class on issue of securities by eminent speaker CS Anshul Jain from Reliance Industries Limited. We have also the presence of Professor Sudhanshu Kumar from Nalsar. Welcome you, sir, to this masterclass series program being organized by the Dr. Manohar Lohiya National Law University, Lucknow. We are indeed privileged to have eminent speakers for today's program. I will briefly introduce Professor Sudhanshu. Sudhanshu Kumar is an assistant professor working at Nalsar University of Law, Hyderabad for last 7 years. He offers corporate and competition law subjects for both undergraduate and postgraduate students. Previously, he has also been engaged in the training administrative officers on the corporate and commercial laws, including competition law. He has also done training program for the tax officers at NADT Nagpur. He has worked on multiple government-sponsored projects. He was also the panelist for the FICCI seminar on the direct selling held at Hyderabad. He has been involved in several publications like SM Dugar Guide to Competition Law, training module for administrative and judicial training academies. It was a project by the Competition Commission of India published in August 2019. Then the Law of Consumer Protection that was published by LexisNexis. He was the specialist editor on the C.R. Datta on Company Law, Treatise on the Companies Act 2013 7th edition that was published by LexisNexis in the year 2017. He has been part of the several projects of the Government of India, like co-investigator to the project, a study to create evidence-based proposal for reform of legal education of India, National Law Universities. This was a project under the Ministry of Law and Justice, Government of India in 2016. He submitted report in March 2018. Another project was a research report on scenario of gaming, esports, and virtual currencies in India. The third project was as a data analyst on the study of code management techniques for improving the efficiency of subordinate codes. Project by the Department of Justice, Ministry of Law and Justice, Government of India 2016. Another project was Repeal Law Compendium Telangana 2017. It was for the Center of Civil Society. He is a keen academician and researcher and has been involved in several projects from time to time. We are indeed privileged to have Sudhanshu ji at masterclass today to introduce the theme for the today's discussion. Let me have a pleasure of introducing our eminent speaker, CS Anshul Jain. He is a general manager working as Reliance Retail Limited. He is a fellow member of the Institute of Company Securities of India, has experience of almost 2 decades in the corporate law, Securities and Exchange Board of India related matters, information technology, prevention of money laundering, stock exchange, arbitration, and several other corporate law related matters. He has worked with the business groups and firms like ITC, Edelweiss, Mehta and Mehta. Presently, he is, of course, working with the Reliance Group. Anshul is hardcore professional, known for his research on various topics. He has helped many Indian companies and multinational companies to implement successfully the provisions of the Companies Act and many other sector specific laws. He has given more than 150 presentations on various topics. He is known for his art of giving and delivering the presentation. His presentation on the board report has been viewed more than 10,000 people, including the regulators like Ministry of Corporate Affairs, and presentation on effective use of information technology has been viewed by more than 15,000 people. So we welcome Anshul ji for this 11th day of the master class being organized by the Dr. Manohar Lohiya National Law University. We are privileged to hear you, get the opportunity to hear you again at this platform. I also welcome Dr. Vishalakshi, Head of Department and Program Director of this masterclass series. Because of her motivation, we are able to conduct and design such type of program for the benefit of all the students. I will request Professor Sudhanshu to introduce the theme for the today's program.
Right, sir. Thank you very much for the introduction. A very good morning to everyone joining us for this masterclass. I thank all the organizers at Ram Manohar Lohiya National University, especially the program director, Dr. Vishalakshi ji, and program coordinator, Mr. Amit Gupta ji, for inviting me to give this keynote address. The topic for today's discussion, which will be taken forward, I'll spend around 10 minutes on introducing the topic and highlight a few issues which I may in that regard, so that that can be taken up forward in the detailed discussion. As I said, the topic for discussion for today is issuance of securities, which includes, as per the detail, includes rights issue, private placement, preferential allotment, issue of preference shares, debenture, issue of debentures, and finally, we will conclude with the topic of buyback of shares. Now, all these, most of these issuances, as we all know, are primary market issuances. Now, if you look at, I have believed that many of the regulations and laws in capital market have been shaped by multiple events in the past. So, for example, some of the events that we will discuss in today's session will be probably the impact of Sahara on our entire understanding of private placement and publication. But before we move into all that, as we all know, Section 23 of the Companies Act talks about issuance of securities. Now, it bifurcates into two parts as different types of company, into private company and public company. And it also makes a distinction between listed entities and unlisted entities. The use of the word securities within Section 23 is interesting, because if you compare this to the previous act in 1956, when you compare, say, for example, Section 42, which talks about private placement, has also used the term security. So it will be interesting to discuss why the term securities has been placed within all these provisions and not use shares and debentures. Because if you remember, again, one of the problems that came in Sahara case was this issue, the use of the word shares and debentures in Section 67, where one of the parties was saying that it does not include hybrid forms. So what I'm trying to say basically is we will discuss the impact of using the term and why we have discussed use the term securities within Section 23. Having said that, the term securities as such, the topic of discussion is issuance of securities. So it's important that we spend some time on the term securities as such. So if you see the Companies Act, the Companies Act does not define in detail what is a security. It refers to another statute, that is your Securities Contract Regulation Act, Section 2H in the definition part, and it says securities means shares, bonds, debentures, and it lists out a number of components within the definition. Having said that, there is a small few words in the definition of the term securities, like other marketable securities, which has received much more discussion. And the courts have interpreted these three words, other marketable securities, to give a certain kind of characteristics to the understanding of the term security. So even if we have any other form of hybrid, say yesterday it was optionally fully convertible debentures and tomorrow it is something else, it can be included in the definition of the term security, and that is why probably the term security has been used in Section 23 and also Section 42. Coming back to Section 23 again, so what I'm trying to say, that there is a certain impact of events that happen in the capital market which shapes our rules and regulations and provisions. So in the capital market issuance also, if you look at Section 23, it bifurcates into two parts, your private company and public companies, and it says that both these two types of companies can raise or issue securities by rights issue, bonus issue, and private placement. The only distinction that is coming for the private and public companies is probably by their own characteristics. That is, private company cannot raise money from public, and that this is the main difference between a private company and a public company, and that distinction is maintained in Section 23. Now, having said that, the public companies can also be categorized into listed and unlisted entities. And when we talk about listed entities, we also have another provision which talks about jurisdiction of SEBI. Now, jurisdiction of SEBI is something which again requires some kind of discussion, right? So if you look at the corresponding, the next section of Section 23, SEBI comes into play as soon as there is issue of securities to public at large. As soon as there is a public offering, SEBI as a regulator comes in, both for issuance of securities and transfer of securities. And he uses the term SEBI has jurisdiction over listed entities and companies which intend to get its securities listed. Now, these terminologies, intention to get listed, requires some kind of discussion. That basically means, what do you mean by intend to get listed? Does that mean every company? Does that mean intention plays a role in providing jurisdiction to SEBI? Is something that we need a better understanding on. So again, your implication of Sahara as a case of Supreme Court order comes into play. Having said that, so you look at Section 23 and it gives us detail about different components of raising funds, say for example through rights issue, when the company issues securities to its own members, or private placement when the company issues securities in a private form. Now, the distinction that Section 23 makes is that for listed entities, apart from the Companies Act, you also have relevant SEBI regulations that comes into play. So if there's a listed entity which is going for these kind of issuance of securities, you also have issue of capital and disclosure requirements that adds on to the Companies Act, right? So that is something we will see as an interplay between your Companies Act and the SEBI regulation. When we talk about private placement, again, I will see, we will discuss probably the impact of Sahara in our understanding. Because if you remember, the 1956 Act did not define what a private placement is, it defined what a public issue is. And the entire contention was raised around Section 67(3) proviso, which said you cannot raise or issue securities to more than a certain number of people. And the number that was used previously in the 1956 Act was was 50. Now, in the 2013 Act, we have taken a different turn and we have defined what a private placement is. And anything that breaches Section 42 in terms of issuance will be deemed to be a public issue. And if you read Section 42, it uses the term 50. No issue of securities can happen to more than 50 people. However, if you look at the rules, it says not more than 200 in a financial year. We will discuss in detail when the detailed discussion happen on Section 42 as to how do we interpret this numeric number of 50 in the main provision, and how do we interpret 200 that is prescribed in the rules of the Companies Act. Also, is it necessary, or why, what is the rationale of a numeric number to differentiate between a private placement and public issue? See, again, we will come back to the standpoint of investor protection as to why SEBI, or in fact the Companies Act, mandate certain kinds of provisions. So if it is deemed to be a public issue, then probably all the requirements, all the compliances, all the necessary requirement that SEBI as a regulator of capital market obliges the party to carry out comes into play. So again, we'll come back to the entire rationale or reason why such a distinction is made between private placement and public issue. Why is that numeric number, or did a certain limitation is provided within the statute? There's a lot of confusion around, and there's a common question that comes around with all the students is, what is the difference between private placement and preferential allotment? So we probably will be able to take more detailed understanding of carving out the domain of preferential allotment and private placement. In the discussion, let me also detail about what other things that we are going to do. So we will talk about Section 23. We'll talk about jurisdiction of SEBI as 23 and 24. We'll talk about private placement under Section 42 and highlight the few issues that I have mentioned. And in this discourse, we'll also talk about different types of shares. We'll talk about issue and redemption of preference shares. We'll talk about why we have provided a limitation on not issuing irredeemable preference shares, why there is a exception that is carved out for infrastructure companies, and what are the conditions for issuing of such preference shares. Along with that, we'll also talk about issuance of debentures, and finally we will conclude with the topic on buyback of shares. Now, buyback essentially is not issuance of securities, but buying back by the company of its own shares. Now, how do we look at buyback within the larger understanding of capital maintenance rule within Section 67 of the Companies Act? This is a similar section that is carried forward from the 1956 Act. There is not much of a difference. But again, on one side, when we say a company has to maintain its capital, coming from the famous Trevor versus Whitworth case, and on the other side, we are carving out an exception for buyback. There are three questions then: what, why, and how. Why does a company go for buyback? Why do we need to create an exception? So say, for example, in the present pandemic times, a company announces a buyback to boost investor confidence. Is it necessary for the company to do that? How does the law allow such buying back of shares? So all the reasons behind why a company is required or is sometimes necessary to go for buyback. Say for example, one of the reasons given is to improve the return on equity. So how does the buyback kind of improves return on equity is something that we have to understand. So the why part of why there's an exception in the capital maintenance rule, why company goes for buyback. What is buyback essentially? Once a company, so it's not a mode of raising fund. it basically company utilizing its funds from somewhere to buy shares from the already existing investors. So how does the company utilize its funds? Where does it utilize its funds? And what does it do once the shares are bought back from the investors? Does it reissue them or does it cancel them? So that is something with the provision details about. So the what part of the buyback, and lastly, how does buyback is operationalized in terms of your regulatory structure? So there are different schemes that are provided under the provision of Companies Act, which talks about how what are the necessary approval regimes, whether it's shareholders resolution, whether it's special resolution, and by what quantum in a financial year you can buy back share. Because please remember, we have to stay within that larger principle of capital maintenance. Company cannot utilize all its capital to buy back shares. So I have just briefly introduced the topic for the purposes of this master class. Just trying to rewind, what we are going to do this is basically two broad themes. One is an issuance of securities, and within issuance of securities, we are looking at different types of issuance within Section 23, and then winding up this class with buying back of shares from the investors, which is not a mode of issuance, not a mode of raising fund, but sometimes a necessity for the company. I will stop here, and I'll allow the next presenter to give you the entire detail of this discussion. I hope this brief introduction works. And I thank you again, the organizers, for inviting me to give this small address.
Thank you, Sudhanshu ji. Your research abilities are very much visible by the theme introduction itself. So indeed, we would be privileged if we can have your detailed presentation at some point of time. I will request Dr. Vishalakshi to arrange the for the benefit of all the participants at some point of time.
Sure, sir.
I will request Dr. Vishalakshi to formally give a welcome note and then allow us to begin the program.
On behalf of Dr. Manohar Lohiya National Law University, thank you, sir, for your ascent to fill up the minds of Indian youth with your specialized knowledge and experience. I hope your expertise will motivate the participants and make them use in their respective field. Welcome to Mr. Sudhanshu Kumar Tiwari for your readiness to participate in this master classes and corporate law program. Thank you for your detailed and thought-provoking introduction. Welcome to participants. Your active and continuous participation is an encouragement to us. Thank you, one and all.
Thank you, Dr. Vishalakshi. Standing as a pillar behind this entire program, designing, architecture, execution, and everything. And now I will request our eminent speaker, yes, Anshul Jain, to take over the session and brief us and make us understand the nuances of the issuance of securities. Anshulji, session is all yours.
Very good morning to Madam Vishalakshmi ji. An excellent opening remark by Shri Sudhanshu ji. And when I was hearing you, Sudhanshu ji, I was thinking that why I am here. I am actually after hearing you, I have the same feeling which Gupta ji shared, that we should rather hear you more than anybody else. And it's just in 10 minutes, we can definitely understand kind of subject understanding you have, and the research, whatever you have done. It's excellent.
Thank you, sir. Thank you for the kind words.
Thank you, Amit ji, for inviting for this particular session. Let me. Is it the screen is visible to all of you?
Yes, Anshul, very much.
So my sincere gratitude to Dr. Manohar Lohiya National Law University for providing me to speak before all the participants of this program. I was told that this is a 15 days program, and few of the sessions I could also attend, and all the eminent personalities like Shri Sudhakar sir, Sir Ravichandran, ji, all those we have heard on various subjects. So excellent initiative by the university, and I was also told that there are various other institutions are also associated with this 15 days program. Before starting my presentation, I would like to give a small disclaimer that whatever I'm going to present here are my own views and nothing to do with the organization to which I belong. And whatever the queries, questions we will be having, I would not be taking any questions which is any company specific or any person specific questions. I'm not going to take. Already spoken by Shri Sudhanshu ji that whatever we are going to discuss. So we will talk on mandatory demat provisions. We will also speak on issue of securities by way of private placements and rights issues. Then we will also speak about preference shares, debentures, buyback. There are certain impacts what may happen when the share capital is issued or bought back. There are certain impacts on certain other provisions of the Companies Act. So those we'll try to see what kind of impacts, and then we can perhaps after having question answers, we can conclude the session. So these are the important definitions which are used in context of issuance of securities. Start with the word securities, as rightly said by Mr. Sudhanshu, that this particular terminology is not, rather it's defined in a different way. It is giving reference to some other legislation. So it says that securities means, which is defined in 2H of Securities Contract Regulation Act. So naturally, we have to see what is defined in Securities Contract Regulation Act. When we look at 2H, so it's an inclusive definition. So when we talk about inclusive definition, so it does not mean that whatever is written, it covers only that. Whatever is written, all the other kind of instrument which may fall within or if it is of the like nature, like shares, script, stock, bonds, debentures, all these are the terminologies which is very commonly used. Debenture, stock, or other marketable securities of like nature in or any incorporated company or any other body corporate. So it's a wide definition is given. It also covered derivatives. It also talks about units of collective investment schemes. So basically, this collective investment scheme, there is separate regulations framed by SEBI for that. Then security receipts, under securitization and reconstruction of financial asset and enforcement of security interest Act 2002. Mutual fund units are also considered as securities. Again, it is governed by a separate regulations of Securities and Exchange Board of India. It also includes government securities, or if any other securities or any other instrument which is declared by the central government as securities, those will also be considered as securities. And the last one is rights or interest in securities. This is another issue, that what may be the rights or interest in any securities. So one of the example in case of rights issue, there is a concept called rights entitlement, which is arising out of uh, rights, which is arising out of shares. So of course, so those rights which is arising out of shares are also considered as securities. So rights entitlement may be considered as securities as far as this definition is concerned. So it's a very wide definition which is given, and remember that this is an inclusive definition. So there may be some other instrument which may fall into the definition of securities. It's just not like by just changing the name, we can do whatever we want. Then we also look at some other definitions which is very general in nature, which we all know. However, just for our understanding, because these are the very important elements as far as issue of capital is concerned, that what is the meaning of the word authorized capital, what is the meaning of the word called up capital, paid up capital, and what is the meaning of the shares itself. So all these terminologies are defined. So it says that shares mean shares in the share capital of a company and include stocks. So basically, not much clarity what exactly share means. So it says whatever is your share capital and whatever is your share in the share capital is considered as share. So this is again a definition which is not exactly giving the meaning of the shares, but we know the general meaning of the word share, so that we have to depend on that. Then authorized share capital or nominal capital, both the terminologies are used interchangeably in the act at various places. It means the capital, the maximum amount of capital which can be issued by a company uh, as per the memorandum of association. So that is your authorized capital, and this authorized capital is also considered for various other purposes, like this payment of various fees to the registrar, also the stamp duties and all. Whatever capital the company has issued and subscribed by the shareholders or any other person. So whatever is subscribed by the members of the company, that is considered as the subscribed capital, and whatever is called for the payment by the companies is considered as the called up capital. Now in Companies Act, there are various methodologies for issuance of securities are prescribed. We'll see all of them. We will also see the administrative power of SEBI under the Companies Act with regard to the securities, mandatory demat, registered valuers. Then we have to also look at the other sector specific laws, like if a company belonging to, say, insurance sector, or it's a SEBI registered market intermediaries, if it is a banking company or any other sectoral sector specific company. So we have to see those sector specific laws also for issuance of securities, that whatever is mentioned in those laws, we cannot ignore those provisions. So we have to see those provisions as well. Then the various disclosures, because the security issue doesn't stop after completion of the process of issuance and allotment and filing of forms and all. It carries by way of various disclosure which is to be made by the company in various documents in after allotment of such securities. So we'll try to see that what kind of those disclosures are. As rightly pointed out by Sudhanshuji, that section 23, actually this is the section which is the section in charge, which deals with the that how a company can issue securities. So there are, depending upon your company, the methodologies are given. If you look at, in case of public company, there are various ways, like you can go for the public offer, which includes IPO, FPO, offer for sell. You can have rights issue, you can have private placement, you can have bonus issue. Then in case of private company, of course, private companies by its nature and also as per the provisions, it cannot go to the public. So therefore, the first option is not available to private companies. So they have the options to raise the capital by way of rights issue, private placement, bonus issue. Now, one notable point here is that the preferential issues are not covered here. So what is mentioned in section 62(1)(c), which deals with issue of secure shares or other securities on preferential basis, then how to use that, because it is not mentioned in section 23. So we will also talk on that what is the difference, and how when 42 will come into picture, when 62 will come into picture. So we'll also talk on that, and we'll try to understand the difference between both of them, or we may conclude also that both are same, whatever. So we will discuss both the things at the relevant time. But the section 23 is the section in charge, that is setting up the boundaries, that how can we issue the various kind of securities, what may be the methodologies for issuance of securities. There are certain administrative powers which are given to SEBI under section 24 of the Companies Act, which talks about powers of SEBI to regulate issues, transfers, etc., as far as listed companies are concerned, and those companies which intend to get their securities listed on recognized exchanges in India. So, so basically, SEBI is a market regulator which is given various powers under SEBI's Act to regulate the market intermediaries as well as listed companies. And not only the listed companies, even the companies which has intent to get their securities listed on any exchange, recognized stock exchange in India. So those companies are also covered under the administrative powers of SEBI, which is and these powers may be related to issuance of securities, transfer of securities, and if any kind of non-payment of dividend by such kind of companies. So those are all dealt by the SEBI under the SEBI Act provisions. So we have ICDR regulations, which talks about issue of capital, issue of then we have debt securities regulations. So all those things are governed by, for as far as listed entities are concerned, it is governed by SEBI's laws, not by the Companies Act. The first question comes that when we talk about issue of securities, that who is having power to issue the securities for any company? So this power is actually coming out of section 179 of the Companies Act. Section 179 says that whatever a company can do, the board, so company means who can do on behalf of company. So section says that unless otherwise specifically mentioned at any other in any other provisions of the act or memorandum or articles of the company or any other law, so whatever a company can do, the board can do that. And certain powers which can be exercised by the board at its meeting only. So power to issue securities is covered under section 179, which can be exercised by the board of a company. So in this, there are various other powers are also there. However, the third one is relevant for us, that is to issue securities, including debenture, whether in India or outside India. So this power can be exercised by the board. So starting point is the board who at its meeting decides whether to issue any kind of securities, or if what kind of securities it can be. Maybe preference shares, it may be debentures, it may be any other securities, it may be equity shares also. But whenever any security issuance matter is there, the starting has to be from the board side, and that too at its meeting. So therefore, you cannot pass any kind of resolution by circulation as far as issue of securities are concerned. This is a very important provisions um, uh, with regard to mandatory dematerialization of securities. We have witnessed that from last about close to 25 years. Now we have the MAT system in our country, and this is a highly successful system for dealing in securities, and very user-friendly system, and also the monitoring as far as securities transaction are concerned is become very easy after introduction of dematerialization, and it is beneficial for all the stakeholders. It may be government, it may be even regulatory authorities like SEBI, even income tax authorities, even Ministry of Corporate Affairs. And as far as investor side is concerned, again, it has given a lot of ease to them to deal in the securities which are in demat form. Before introduction of Companies Act 2013, this mandatory demat we have seen as far as market trades are concerned. We have seen it was already there, which was governed by SEBI. First time we have seen the provision for mandatory demat. So what this provision says under Companies Act that whenever you issue any kind of securities, so any listed entities issuing any kind of securities, it has to be in the demat form. But it has also given the power to the this issue of the issue and transfer of securities has to be done in demat form by any public companies who is going to make any public offer. So this provision was already there in some other law. However, this Companies Act has given the power to MCA to prescribe uh, the class of public companies for issue of securities for mandatory demat. So what does it mean that whenever these kind of public companies, the prescribed class of public companies, whenever they are issuing any kind of securities, it has to be in mandatory demat form only. So no physical share certificate will be issued. Whatever shares are allotted will be credited in the demat account of the applicants who is applying for the securities, and it is mandatory. So companies are also not having any choice to issue the securities in any physical form. Now, what this is this is a power available to the ministry. So what the Ministry of Corporate Affairs has done, they have prescribed the class of companies as unlisted public companies. So unlisted public companies, whenever they are going to issue the securities, they have to go for the mandatory demat. Now, in the Companies Act 2019, there was an amendment which says that MCA also got the power to prescribe the class or classes of unlisted companies for transfer of securities in dematerialized form. Now, as far as issue of securities is concerned, it mentioned prescribed class of public companies. Whenever it talks about transfer of securities, so it says unlisted companies. So unlisted company, it may include even private companies also. However, this power is yet to be utilized by the ministry, but sooner or later we may see that the ministry may make it compulsory to, even for private companies also, uh, to go for mandatory demat if they wish to uh, if any transfer for those private company happens in so it has to be in the demat form only. So this is what the which is the power is already with the ministry. It's just a description of the rules as and when it comes into force, and then we have to follow the provisions for mandatory transfer, mandatory demat provision as far as transfers of securities are concerned. And as far as issue is concerned, of course, it is already there for unlisted public companies that we can issue the securities only in demat form. So new rule which was prescribed by the ministry somewhere in 2018, and it's rule 9A. It says that that other class of companies that I was talking about is nothing but the unlisted public companies. But there are three kind of entities which were exempted from this rule 9A. So those three kinds of companies are Nidhi companies, government companies, and wholly owned subsidiary companies. So these are the three different categories where if those companies are issuing any kind of securities, so they need not to go for the compulsory dematerialization. Now, if you look at the wholly owned subsidiary, of course, this terminology wholly owned subsidiary is not defined under the Companies Act. So again, we are depending upon more on the general understanding that what can be our wholly owned subsidiary. But if you have to look at that, what will be the after effects? So there is a possibility that the company is issuing presently, say there is a company called H Limited, its subsidiary is say S Limited, and this S is the wholly owned subsidiary of H, and this S is now issuing the shares, and this shares is on private placement basis to some third party. So the moment the allotment is made to the third party, it is no longer an wholly owned subsidiary. So what we need to see, whether the after effect we have to see now, or we have to see at the moment when we are issuing the securities. So my understanding says that you need to see the at the time of issuance of the securities, what is the status of your company. If it is wholly owned, then you need not to go for the mandatory demat. But the moment allotment is made to any other parties and you're no longer a wholly owned subsidiary, then of course for all subsequent issue of capital, you need to go for the mandatory demat provisions. Of course, this rule says that any issue of securities only in demat form. Not only these rules deals with the issue of securities in only in demat form, it also talks about that facilitate the company needs to facilitate all its existing securities in for dematerialization also. So there are two scenarios. One is when I'm issuing the securities, and if I am having the existing securities, so I have to make those or provide the facilities to for the dematerialization also for my existing securities. A very important provision, it says that all the holdings of your promoters, director, and KMP has to be in compulsory demat form before issuance of any securities. So if you have even a single share which is in the name of, say, your director, which is in physical form, and you want to come with issue of securities, so you have to make sure that those, even that single share which is in the name of your director, is converted into demat form before issue of securities. Otherwise you will not be able to issue the securities. And it does not mean that if you have the equity shares, if the director is holding equity shares, say one equity shares in physical form, and you're coming with the preference issue of preference shares, then can we say that since the director is holding equity shares and we are issuing preference shares, so he need not to go for the compulsory demat? The answer is no, he has to go for the compulsory demat, because it talks about the issuance of any securities, and before issue of such securities, whatever the holdings of any kind of security has to be converted into compulsory dematerialization, demat. So those securities are to be converted. That director has to open the demat account with any of the depository participant, submit the necessary documentation, and then thereafter those securities will be converted into dematerialized form. Even if you're going for the buyback, you're going for the issue of bonus shares, even if you're going for the rights offer, whatever you do, you have to make sure that before issuance or before buyback or before issuance of bonus shares or making any rights offer, you have to look and see whether any of your promoter, director, or KMP, either of them is holding any single share, even any single share in physical form. If the answer is yes, then you have to make sure that those shares are dematerialized before issued. It also says that because these rules, this particular rule 9A was made effective from October 2nd, 2018. So it says that any holder of securities, if wants to transfer any shares on and after October 2nd, 2018, then it has to be in compulsorily demat form. So even an unlisted public company shares cannot be transferred if it is in physical form. It has to be in dematerialized form only if you want to make any transfer. It does not say that you just compulsorily convert your security in demat form. It says if you wish to transfer, you have to make it dematerialized first, and then only you can transfer. As far as promoter, director, and KMPs are concerned, again, the section does not say, or rules does not say that you make it demat now only. It says before issue of security, you have to make it demat. But you never know that when the proposal of issue of securities may come into place, and this process of dematerialization may take some time to complete, especially circumstance like today, where lot of operations are shut, you cannot move out, and also it's very difficult to get the securities dematerialized at this point of time. And if we have the proposal handy with us for the raising of capital, but we are just stuck because our securities are not in demat form. So it is always better and suggested to keep all your securities dematted, and especially of your directors, KMPs, and promoter. So at least your proposal can start without any hassle. And any person, if he wants to subscribe any securities by way of either private placement, bonus shares, right shares, whatever, it has to go from your side, from the company's side, in demat form only. So if any person who is having the physical shares, and his or he may not be having shares also in case of private placement, if it is some third party, if is applying or is subscribe, making an application for subscription of securities in private placement, you cannot issue the shares or you cannot allot the shares to him unless it is in demat form. So that also needs to be taken care of. Otherwise, his application you have to, reject if demat account details are not provided. So this is a very critical provision in terms of issue of securities. This provision also talks about obtaining of ISIN and intimate to its existing securities holder. So whenever you want to go for the demat, so company has to uh, obtain this international securities identification number, and this number is also required to be intimated to all its existing security holders. Another very important provision with regard to issue of shares, that it makes timely payment of fees, whatever kind of fees it is. It may be the admission fee, it may be the annual fee to the depository and registrar to an issue and share transfer agent in accordance with the agreement executed between the parties. Not only this, this rule also says that you need to maintain security deposit at all the times, and the amount is also given that of not less than 2 years of fees with the depository and registrar, um, in such form as agreed between the course parties, and whatever directions are given by SEBI with regard to dematerialization of shares, it has to be followed. Why I said that this, even the fee payment is a very critical provision, because of one of the rules says that, one of the sub rules says that no unlisted public company which has defaulted of this payment of fee or maintenance of security deposits and all shall make any offer of any securities or buyback of securities or issue of any bonus shares, right share, till the payments to depository or registrar or share transfer agents are made. So this can also create a issue while when you are going for the issuance of securities. So you have to make sure that all the payments and the security deposit are maintained, payments have been made, there is no default. Otherwise, this rule is again, creating a roadblock as far as issue of securities are concerned. This is this also needs to be taken care of. Then this rule also says that the company is covered under this rule is required to file a form called PAS 6 to the registrar. Of course, and it has to be certified by company secretary in practice or chartered accountant in practice. However, though the rules came in the rule came in the year of 2018, and this form is required to be filed in every half year within 60 days from the close of that half year. So so for March 31st, then September 30th, and so on, you need to file this form. However, the form is yet to be electronically deployed by the ministry on its portal. So ministry has given a clarification by way of a circular saying that till the time this form and is not deployed by them, the company need not to worry about this filings and all. And as and when the form will come, they need to file the form. So practically, as on date, this PAS 6 is not available for filing. So therefore, you need not to worry about this. However, as and when, so it may come even next 2 hours also, we never know. So whenever it will come, you have to make the necessary compliances. With regard to any kind of grievance of securities holder of unlisted public companies under this rule shall be filed before the Investor Education and Protection Fund Authority. So IEPF authority is the jurisdictional authority for handling the grievances for under Rule 9A. And IEPF authority is also empowered to initiate any kind of action against a depository or participant or registrar or share transfer agent after prior consultation with the SEBI. So this can also be done by IEPF authorities. Now we come to the private placement of securities. So this section was originally, when it came in 2000, effective from April 1st, 2014, and in 2017, by 2017 Amendment Act, this entire section is substituted with a new section 42. So what we are going to deal with the new section 42, which is there as on date in the statutes book. So interestingly, this section 42, if you look at, it uses the word shares in its heading. If you look at the heading of this particular section, it talks about shares. However, when you look at the entire provisions, it all everywhere it talks about securities. Of course, so though the word share is used in heading, but of course we have to go with the we have to read that shares as securities only, because the entire section talks about securities. It is only the heading which is saying which is using the word shares. There are certain critical provisions which are there as far as this particular section is concerned. Now there is a very important provision which Shri Sudhanshu also spoke, that any private placement issue which is not made in compliance with the provision of this section shall be deemed to be a public offer. Now, not in compliance of the provisions of this section, it's a very wide term. Even a small non-compliance, whether so there is no size is given that to which extent, which subsection, which rule and all. It's a plain section. It says that any private placement issue not made in compliance with the provision of this section in section 42 shall be deemed to be a public offer. And the moment it become the public offer, the SEBI will also come into picture. And we know historically that what may happen. So according to me, when we interpret section 42, we have to make conservative approach. We should follow the conservative approach of interpretation. If rather this conservative approach can be for in various other provisions of the Companies Act also, but this is a kind of provision which can impact very badly to the not only to the operations of the company, but even to the existence of the company also. So we have to be very careful while making any kind of interpretation in this section. This section says that you can issue the securities to select group of person which is to be identified by the board. So board will, in its resolution, when they will pass for the issuance of securities, will identify that to whom this securities are to be issued. Now the word uses person. Now, what is the meaning of the word person here? Whether it is talking about individuals, or whether it is talking about when I'm talking about the word person, the person means do I need to give the name of the person, or can I define the class of the person also in this? Uh, Give me a moment, please. Yeah. So so even a class of a person. So can I say that in my identified group of person includes all the banks, all the mutual funds, because they are also the persons. So can I make such kind of interpretation? Again, it's according to me, a bold interpretation to take. It's always better to name the person rather than select the class of person. So the section doesn't say like this. It's simply saying that the select group of persons. So I'll say that the bank is a group. I have selected that. Mutual fund is a group. I have selected that. Those can come in the private placement, or any other such kind of group of persons can. But again, it's a bold. According to me, it's a bold kind of interpretation. So it's better to identify by name that Mr. A or ABC Limited or something like that as identified as far as this identification is concerned. Then it also says that the whatever issue on private placement basis we are going to make is to be authorized by the articles of association of the company. So if there is no specific power in our articles, then we have to make sure that the articles are amended suitably to incorporate this power. Then we have to obtain the board approval or audit committee approval for the appointment of registered valuer for the valuation of securities. So section 247, which deals with appointment of registered valuer for the valuation, it says that wherever the audit committee's provisions are applicable, so we have to obtain the audit committee approval for appointment of registered valuer. So therefore, we have to go to the audit committee. If no audit committee is there, then we have to go to the board for the appointment of registered valuer. We have to obtain the valuation report from the registered valuer. Price of the securities to be issued shall be based on based on this valuation report, whatever we will obtain from the registered valuer, and it should also not be less than the price determined in that report. So if my valuation report is saying that the securities can be issued at rupees 100 including premium, so it should be at rupees 100, not below that. It has to be on the, it may be on the higher side, of course, subject to other laws, but it should not be less than the price determined by the valuation report. There is another provision that you have to have a separate bank account with the scheduled bank for the purpose of receiving of the share application money, and you have to draft the private placement offer cum application letter in form PAS 4. So there is a format of format prescribed, which is form PAS 4 of the PAS in company's prospectus and allotment of securities rules, with which contains a lot of details about the companies and the offer and other things, which we'll see in some time. So those details are to be provided. And as I said earlier, that this power to issue securities is with the board. So 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 of course you have to have a board meeting to approve the issue of securities on private placement basis. You have to draw and you have to also approve the draft private placement offer cum application letter. You have to record the name and address of the identified person, authorize directors, KMPs to allot the shares. You have to open a bank account if it is required to open. If you already have some account which is already opened before, so no need to open further account, you can utilize that particular account, provided it's separately marked for this particular purpose. Then also you have to approve for convening of the extraordinary general meeting of the company. You have to also approve the draft notice of the EGM of the company. And once all these things, to approve all this, you need to hold the board meeting. And as per the requirement of 179, read with 117, you need to file form MGT 14 for issuance of securities for this board resolution. After completion of the board process, then you need to dispatch the notice of your general meeting for the approval of the members for issuance of securities through private placement by way of a special resolution. So members has to pass special resolution for that. And this valuation report is to be annexed along with the notice of the EGM. You have to receive then the company will receive the duly filled in and signed private placement and application forms along with the subscription amount. The subscription amount has to come from either through check, demand draft, and credit to the separate bank account of the companies. And we have to make sure that this payment of money, whatever we are receiving, this payment should come from the respective account of the shareholder only. So you cannot use any third party account for the receipt of the money. So that necessary checks and balances you have to build in. So if you are having the demand draft, so you have to obtain some kind of confirmation from the bankers, or that this particular demand draft is made out of the account of the person who is applying for the shares, or if it is check, you have to make sure that the checks are uh, pre-printed with names and all, so that you can very well you know check whether this checks are issued by the respective same person only or not. So these records you have to keep with the company, and you have to maintain the complete record of private placement offers in form as 5. After entire documentation which you have received, you will of course verify all the applications and whether it is complete in all respect or not. And after that, the company will allot the shares to the identified person. This allotment process is to be completed within 60 days from the date of receipt of the application money. But one thing is very, very important in this entire process of private placement, that unless the shares are allotted, and return of allotment towards that allotment is filed, till the time you cannot use, or you cannot utilize this money. So of course, I don't think the companies are going to wait for 60 days just keeping the funds ideal in a separate bank account without touching it. There is no point of doing it. If so it's sooner is the better. So you, when the moment you will allot the shares to the identified person, and also file the return of allotment within a period of 15 days, then you can of course utilize the money. And you need to pay the stamp duty in respect of the shares allotted. So we have new rules into force with effect from 1st of July 2020 for payment of stamp duties. uh, After that, you need to complete the corporate action. uh, you need to file this corporate action form to the depositories for credit of those shares allotted to the identified person. And as I already mentioned, that the money can be utilized only after filing of PAS 3 with the ministry. And of course, you update your other records and communicate with the various other functions. So when you have received the money, when you have allotted, so once the allotment is done by the, so you need to communicate to the other functions of the companies also, that this allotment process is completed and the form has already been filed. So accordingly, the money can be utilized. There are some important points that as I have already mentioned about this point, that you need to check the status of your demat shares for so the identified person who are applying for the shares, we have to make sure that they have the demat account number mentioned in their applications, along with if possible, take the proof also that the demat account belongs to them. Of course, we need to check the sufficient authorized capital, because we have seen in the definition that this is the maximum amount which a company can raise. So we should have that much buffer available with the company. Then, in case any third party consents is required for issue of the further securities, so it generally in the lender's agreement there may be some clause that whenever company issues the further securities, it has to take the prior consent from the lenders. It may be in a JV agreement, there may be some clauses which may say that whenever companies are issuing securities, it has to first obtain the consent from both the JV partners. It may happen so before issuance. So therefore, all such kind of consents, etc., whatever is required to be taken from the third parties before issuance of such securities, so those things are to be taken into account. This is another very important provisions, that we need to ensure that at the time of passing of the board resolution for issuance of securities, no other offer or invitation is open. Uh, and all earlier offers have been completed or withdrawn or abandoned by the company. So today, if I have my board has passed the resolution, say for issuance of equity shares to some specific identified person, and I'm not and tomorrow my board wants to issue another kind of securities to some other person, so I have to make sure that my all earlier offers either completed or withdrawn or abandoned. If it is not there, then I cannot come with the fresh private placement offers. That is a very, very important provision. Then this is another interesting provision, that the offer or invitation to subscribe securities under private placement shall not be made to the person more than 200 in an aggregate in a financial year. Sudhanshu ji has already mentioned about these numbers, 200, and earlier it was 50. So, so I think these numbers are more arising from the definition of private companies, because earlier the private companies, the maximum number was permitted 50, and now it is 200. So these numbers are actually coming from those. So regulator has also thought of that up to 200 there is no problem. If you are going beyond 200, then it may be termed as a public offer, and accordingly you need to come with the other provisions, whatever is applicable as well. And only the identified person to whom the board has identified can apply in this issue. No third party can come and just simply apply. Another important provision, that you should not make any kind of public advertisement or utilization of media marketing distribution channel. We should not use for this issue. So as a process, we have to be very, very careful whenever we are coming with such kind of issue. You should not simply, click the image of your offer letter and circulate circulate to buy.
Anshul, now you can connect. It's working. There was some technical issue at the end of the WebEx, and audio suddenly went off. WebEx has restored the audio. I hope now I'm audible, and we should be able to continue the presentation. Speaker has also joined. Anshulji, I will request to continue from the place where we stopped. Maybe you can take 5 minutes back, because I believe there was some issue prior also, which we got noticed little later. There was some issue at the WebEx end itself. Now they have just resolved.
Okay. Can you allow me to share the presentation, please?
Yes, done, Anshul, please.
I hope my screen is visible now.
Anshul,
Yes,
please
sir.
go ahead.
Okay. I think I can start from here. Yeah. So we were discussing about this private placement, and so I was mentioning about something that there is an important point which is to be noted uh, in private placement rules, that if you look at the proviso to Rule 13(1) of Company Share Capital and Debenture Rule, which refers to the Rule 14 of Companies Prospectus and Allotment of Securities Rules 2014. Now, what has happened that, as I have already mentioned some time back, that this is a new provision. So while drafting the new rules according to the new Section 42, the cross-referencing with other rules is not taken care of properly. Of course, this needs some kind of clarity from ministry side, and I'm sure they will do this particular issue, this cross-referencing issue, clarified sooner or later. So basically, if you look at the proviso of Rule 13(1) of Share Capital and Debenture Rule, it says that in case of any preferential offer is made by the company to one or more existing members only, then the provision of Sub Rule 1 and proviso to Sub Rule 3 of Rule 14 of Prospectus and Allotment of Securities Rules, which we are dealing with as of now, shall not be applicable. Now, if you look at these Sub Rule 1 and proviso to Rule 3 of 14, in the context of Rule 13(1), both are not gelling with each other as of now. When the earlier provision was there, of course, it was completely gelling. At present, it is not. This cross-referencing has become incorrect as far as the present rule is concerned, and it's difficult to understand that what to comply and what not to comply. But of course, this apparent drafting issue which can be sorted out by the ministry sooner or later. So this is another into. Now, there are certain disclosures which are required to be made as far as Section 42 is concerned, that what is the object of the proposed issue for which you are raising the money, total number of shares and other securities which you are going to issue, proposed issue price, or the price band, basis on which the price of securities has been arrived. So, of course, it is based on the valuation report issued by the registered valuer, as we have seen before. Uh, classes and class of person to whom the proposed to be made, intention of promoter or directors or KMP to subscribe, proposed time period for completion of allotment. All these are the various disclosure which are supposed to be done in this entire process of private placement, which includes also change in control. So it's a long list of various disclosure if consideration is other than cashed in the justification, pre and post issue shareholding pattern, particulars of offers, including date of passing of board resolution, kind of securities offered. So all these are the disclosure which we need to make as far as private placement process is concerned. Now we come to the another process of section uh, 23. We have seen in 23 there is a process of private placement, there is a process of rights issue. So we will see that section 62, which talks about various other mode of issuance of securities, includes rights issue and preferential issue, which we are going to deal with. So first comes to the rights issue. It's a very common, it's a most easiest way of raising the capital in terms of process part is concerned. So rights issue, as we are aware that when we issue the shares to the or securities to the existing members of the company in the ratio of their existing capital, so that is considered as the rights issue, and the board need to decide on this, because again, is the power to issue the securities is with the board, as we have already seen. No shareholder approval is required. Of course, if your article says so, of course, there is a remote possibility that the article will have such kind of provision. But still, if the article says so that the for any kind of issue of securities, the shareholders approval is required. So even you have to go to the shareholders for even for the rights issue. That then the rights in rights issue, right to renounce the shares or is also available. Of course, this provision should be there in the articles of association. Letter of offer you have to prepare, but what format, it is not prescribed. There is no specific standard clauses which is prescribed by the ministry, so you can design as per your choice this letter of offer. And the offer has to be shall be made by the notice specifying the number of shares offered. So in the offer you will mention that how many shares you are offering, and there is a 15 days time you have to give for subscription. The maximum is 30 days. So 15 to 30 days your offer should remain open, within which if it is not accepted, it shall be deemed to have been declined. Now this provision is also proposed to be amended in Companies Amendment Bill 2020, which is yet to be passed by both the houses of parliament. So it is under proposal that this 15 days time limit, the ministry is getting power that the ministry may for such classes of company, or it can decide to further reduce the time of this 15 days. So which is rightly so, is a very need of this reduction of time of 15 days, especially for the smaller companies which comes for the which are raising the capital from a very limited set of people. There are 7 shareholder, all paid the money and all those things, but still you have to wait for 15 days time. So these are to be such kind of issues can be taken care of once this CAB 2020 is passed and ministry prescribes those provisions in the rules. Then whenever we comes with the right issue, so whatever number of securities I am offering as part of my rights shares, and the entire issue is not subscribed, so the remaining portion board of directors may dispose of in the manner which is not disadvantageous to the shareholders and the company. So you have to take care of both the scenario. It should not be disadvantageous to the shareholders also and to the companies also. And this letter of offer has to be dispatched through the registered post, speed post, electronic mode, or courier, or any other mode which can give the proof of delivery to all the existing shareholder at least 3 days before the opening of the issue. So effectively, what happened uh, once the issue is decided by the board and letter of offer is also approved, you have to wait for you have to dispatch it, then wait for 3 days, then issue the open then you have to open your issue, wait for 15 days to close it, or 30 days is the time whatever is decided by the board, but minimum 15 days you have to keep it open, and then receive the money during this process. And then and of course there are certain provision which was there in the private placement that you cannot utilize the money unless you file the form and you allot the share. Such kind of provisions are not there in case of rights issue. Uh, then there are certain relaxation which are given to private companies in terms of some timelines. It says that if the 90% of the members of a private company have given their consent in writing or in electronic mode, the period lesser than 3 days and 15 days shall apply. So in case of private companies, of course, if you want to reduce that 3 days waiting period, the initial waiting period, and 15 days time if you want to reduce, so you can do it, provided you get the consent, um, you know upfront consent from the 90% of the total number of members of a private company. So that you need, if you have that, then you can have the even lesser period also. A very important question can rights issue be a substitution of private placement? So this particular issue is dealt by Kerala High Court, single bench, then division bench, and followed by Supreme Court in this case of Kunnam Kullam Paper Mills Limited. What this company has done, they came with the uh, rights issue where the shares were renounced. It was, of course, under the old act. So the limit was under private placement, the limit was 50, and the shares were renounced to 163 people. And the SEBI came with the observation saying that it's nothing but a private placement because you are issuing shares to more than 50 people. So it should be considered as the public offering, not a rights issue. Of course, the company made its own justification that it's a rights available under the provisions of the act. So shareholders have renounced it, and therefore it should not be termed as public offer and all. And the company's plea was accepted in the Kerala High Court before the single bench. However, when the matter went to the division bench of the Kerala High Court, the matter was decided in favor of SEBI, where it was said that the SEBI contention are correct, and therefore this should be termed as private placement, or sorry, this should be termed as a public offer, not the rights issue, and accordingly the company can be subject to actions by SEBI under the various provisions for non-compliance of regulations related to public offer. Now, this was a judgment given by division bench. Then this company went to the Supreme Court. The Supreme Court, even without hearing the matter, says that there is no merit in the matter, and the accordingly the High Court the division bench judgment is also upheld by Supreme Court. So this particular scenario we have to see. You can use it, but has to be use it very carefully, keeping in mind various factors. Uh, of course, your intent will also work behind all this. So if apparent it is looking like that it was this right issue is done just to circumvent the provision of private placement, it can be hit back very badly to the company. So therefore has to be utilized very carefully. It should not be intentionally used as a substitution of private placement. That's what I can say. Then what about the dematerialization of shares? Of course, in case of, as we have said, this is a precondition. You cannot allot the shares to the applicants who doesn't have demat accounts, so that needs to be taken care of. Also, in case of rights issue, it's a precondition. Then come to the preferential offer. Now, let me tell you something that if we have seen section 23, it talks about rights issue, it talks about private placement. So these are the two processes for issuance of securities. Whatever other processes are prescribed, those are the add-on processes. So suppose if I'm talking about issue of shares on the preferential basis, this is nothing but an add-on process. Add-on process means I have to necessarily follow section 42 if it is on private placement. There is no second thought on that. Or if it is not private placement, I'm coming with the rights issue, I will follow the process given 62. So I have to follow either of these two processes depending upon the case. Rest all are the add-on processes. So it cannot happen that I am coming with the preferential offer without following section 42. The section 42 is inbuilt process section. It is given in the section in charge that we have seen, section 23, that is there, that you can issue the securities by following this process. So you have to keep in mind that the private placement you have to follow. These are the add-on processes. Now, what these add-on processes says that whenever company is coming with an issue of shares or other securities to a select group of person and all, then of course you have to follow 62(1)(c). But this also says that shares or other securities means what? because this section 62(1)(c) uses the terminology shares or other securities. So it says that shares or other securities means equity shares, fully convertible debenture, partly convertible debenture, or any other securities which would be converted into or exchanged with the equity shares at later date, right? So if we look at the scope of section 62(1)(c), it's limited to the shares or other securities. And what is other securities? Which either fully convertible or partly convertible, or any other securities which would be converted into or exchanged with the equity shares in later date. So that is the part of your preferential offering. So if you are issuing, say, debentures, which is non-convertible, on private placement basis, do I need to look at 62(1)(c)? The answer is no, because it is not falling in the definition of other securities. So I need to follow 42 read with 71. If I am issuing preference shares on the basis of say if I am issuing only redeemable preference shares, so what I need to follow? Do I need to look at 62(1)(c)? Answer is no, because there is no convertibility attached to it. But suppose I am issuing, so I need to look at, in case of issuance preference shares only, which is only redeemable preference shares, I need to look at 55 and 42. But suppose I am issuing compulsory convertible preference shares or compulsory convertible debentures, or I am issuing optionally convertible debentures, right? So partly convertible debentures or any other securities which would be convertible or exchange with equity shares. If I'm issuing those kind of debenture, then what I need to look at? I need to look at 42 also, and look at, in case of preference share, I need to look at 55 also. And since convertibility is there, I need to look at 62(1)(c) also. So this is a difference of when this process will. This is not a process in its itself. This process is an add-on process, and it will depend upon the kind of security which you are issuing, whether this process will come into picture or not, because of this definition used in this particular section. Now another question, why I said so, whether 42 is applicable or not. Of course, it was earlier clarified by way of rules that whenever you follow 62(1)(c), the 42 will also come into picture. But now, after the amendment made in Companies Amendment Act 2017, this provision is made in 62(1)(c), which says that you can issue the shares on the basis of this preferential offer if it is authorized by special resolution, whether or not those person referred in clause A or clause B means these right shares or ESOP, either for cash or consideration other than cash, if the price of share is determined by valuation report of a registered valuer, subject to compliance with the applicable provision of chapter 3 or any other condition as may be prescribed. If you look at the entire chapter 3, so in this chapter 3, only this section 42, which deals with shares to select a group of person and all, rest all the sections mostly are talking about public offering and all. So chapter 3, so this is this provision, this reference of chapter 3 in section 62(1)(c) was not there earlier, but it was coming out of rules. So there was always a debate whether the rules can talk of such kind of things or not. But now it is very well clarified in the section itself, which says that you need to also look at the relevant provisions of chapter 3 when you are making the when you are making the preferential offer as per 62(1)(c). Of course, whenever you are coming with the preferential offer, you need to look at the conditions which are prescribed in Rule 3 of shares capital and debenture rules also. So Rule 13 you need to see. So what are the various conditions which you need to follow? Of course, you should have the provision in the article, authority by way of a special resolution, which you will follow in 42 also. The provision should be there in article. So whatever not mentioned in 42 but mention is here, you have to comply, or whatever is not mentioned here but also mentioned in 42, you have to comply. So you have to mix both the provisions and remove all the duplicate provisions, and then create your documentation according to that. Then you have to also give the various disclosure in explanatory statement of which is going to be with your special resolution. Then determination of conversion price. So how you can decide the conversion price? It can be decided upfront, or if you do not want to decide it upfront, so you can decide it whenever the shares are going to be converted. So 30 days prior, you can decide the conversion price. Price is to be determined, of course, on the valuation report by the registered valuer. And if you are issuing the securities consideration other than cash, then that valuation is also to be done by the registered valuer. And the similar provision is also here, that the price of shares or other securities to be issued on the preferential basis shall not be less than the price determined on the basis of the valuation report. So that is another provision. You cannot go below the price which is decided by the uh, registered valuer in his report. And the entire allotment process is to be completed. Once you pass the resolution, you need to make sure that your allotment process is completed within a period of 12 months. When I'm saying allotment process, once you have received the subscription amount, then you need to make sure that within 60 days you made the allotment. But this is the entire process. Once the resolution is passed, you will not receive the subscription money, but the resolution is passed. So that offer an allotment, and that entire process should be completed within a period of 2 months. But once the subscription money is received, make sure that the 60 days timelines are not breached. Then in explanatory statement, you have to make various disclosures. Now, we have to also look at one important provision in 62(1)(c) and of course in 55 and other provisions. There are certain disclosure which are required to be made in the explanatory statement, and there are certain disclosure which are required to be made in resolution. So we have to while drafting the document, we have to be very careful that what is to be disclosed in the explanatory statement and what is to be disclosed in resolution. And another question comes because explanatory statement is arising out of section 102. And 102, subject to certain condition, doesn't applicable to private limited companies. So do we need to say that in case of a preferential offer by a private company, I need not to make any kind of explanatory statement because I am exempted? So you're exempted under 102 wherever the specific reference of explanatory statement and its disclosure is coming in the act. Specific reference like this particular section which says that you need to give these many disclosure in your explanatory statement, then of course you have to follow the provisions of this explanatory statement without any you know this thing that it is, since I'm a private company, so I need not to do it. It has to be given, right? Then the okay, there are certain other disclosure that the class or classes of person to whom the allotment is proposed to be made, intention of promoter. This we have also seen in case of uh, private placement, but there all these conditions were mentioned in the offer document also. Here we need to mention in the explanatory statement proposed timelines, name of the proposed allottees, and percentage of post uh, preferential offer capital that may held by them, change in control if any, number of persons to whom the allotment is going to be there, and number of persons to whom the allotment was made during the year, justification of the allotment proposed to be made for the consideration other than cash together with the valuation report, pre-issue and post-issue capital. I need to give all this disclosure while issuing 62, following the process under 62(1)(c). So remember, again, I'm repeating that this particular process is an add-on process. This is not an independent process. I cannot decide that I will issue the equity share just by following 62(1)(c), not following 42. 42 in any case you have to follow. That is a standard process. This is an add-on process. Now come to the issuance of preference shares. law is very clear that you can issue only redeemable preference shares. You cannot have irredeemable preference shares. However, if you look at the Schedule 3, which talks about various disclosures to be made in the financial statement, there is a reference of irredeemable shares, irredeemable preference shares. But that disclosure is actually redundant because section per se doesn't allow you to issue irredeemable preference shares. So you can have only redeemable preference shares for a maximum term of 20 years. And I think in the opening remark, Sudhanshu ji talk about that for infrastructure companies and infrastructure project, it can go up to 30 years. But you have to make sure that after 20 years, you make a 10% redemption every year. So during that span of 10 years, your entire preference shares gets redeemed. So that you need to take care of. Of course, you should have the provision in your articles that you can issue preference shares, and your authorized capital should also be suitably, inbuilt so that you can suitably divided so that you can issue equity as well as preference shares. And you should not have any subsisting default in redemption of preference shares and payment of dividend. So if you have any kind of default which is going on, so you cannot issue further preference shares. And there are certain provisions with regard to the redemption of preference shares. So as far as redemption is concerned, it can be done by the proceeds of the fresh issue, or it can be done by the profits of the company based on the financial statement of the company, whatever profits you have. So you can redeem your preference shares out of that profit. And if you're utilizing the profits for the redemption, then make sure that the equal sum is transferred to the capital redemption reserve account, which can be utilized further for the issuance of bonus shares and all. So this you need to take care. Now, when you issue the preference shares, so these many disclosures you need to make in the resolution. Remember, these are the disclosure which are you need to give in the resolution, not the explanatory statement. What's like we have seen in earlier, I have already mentioned about it, that you need to read carefully that where the word is resolution is used and where the word explanatory statement is used. So here you need to see that you need to specifically mention that the priority with respect to payment of dividend or repayment of capital vis-a-vis equity shares, whether these shares will be participating or non-participating preference shares, means after the winding of whatever surplus remains, whether they can further entitled to get contribution from that surplus funds or not. So you need to mention that participation, then the payment of dividend on cumulative basis or non-cumulative basis, conversion of preference shares into equity if it is convertible. So you need to mention about whether the shares will be convertible or non-convertible. Then the voting rights, we'll talk on this voting rights little later. Then redemption of preference shares, how the redemption will be done, whether it will be redeemable, and up to what period, and all those things you need to mention in the resolution. And these are the disclosure which you need to make in the explanatory statement. So earlier, whatever we have seen is the part of your resolution itself. Now this is the part of your explanatory statement, that the size of the issue and number of preference shares to be issued and nominal value. Again, remember one thing, that you need to look at that which process you are following. If you are following 62, you are issuing preference shares on private placement basis. So you have to follow section 42. You have to follow section, and if it is convertibility is attached to it, then you have to follow 62(1)(c) also, and you have to follow 55 also. So there are three type of processes which will come into picture: 42, 62(1)(c), and 55. So these are whatever I'm explaining at present, it is given in 55 also, but it does not mean that if you are issuing on preferential on private placement basis or preferential basis, then you need not to give those disclosures. Those disclosures are to be given in compliance with the provisions of those particular sections. These are again further disclosure you need to make. More or less it may remain same, like objective of the issue is there also in 62 also, in 42 also. So whatever are the repeating, you can you need not to give 3 times, of course, you can give only once. But whatever are the additional provisions, those are required to be specifically inbuilt in your documents. So these are the disclosures in explanatory statements. Right. So now come to the debentures related provisions. So debenture, this terminology is defined under section 71 of the in Companies Act section 2, which says that the debenture includes debenture stock, bonds, any other instrument of a company evidencing the debt on the evidencing the debt, whether the constituting a charge on the assets of the company or not. Now, this has created a problem, specifically the word evidencing a debt. So even the companies which are going for some short-term financing in form of, say, commercial papers and all, so they were facing a difficulty that it is falling in the definition of debenture because it is also evidencing a debt. So they have to go with the process of and if it is a security, if it is a debenture, it is a security, then you need to go with the section 42. If it is convertible, then 62(1)(c). So all those provisions come into picture. So to carve out that of course this provision was already there in the rules, which says that the in case of issuance of commercial paper, the provision of this rule shall not be applicable. But again, it was given in the rules, not in the main section itself. So on the basis of the recommendation of Company Law Committee in 2016, these provision was amended, and in this amendment, these two part, these two proviso were added, says that the whatever the instrument referred in Chapter 3D of RBI Act and such other instrument which the central government prescribed shall not be treated as debenture. So commercial paper by its definition itself is out of the purview of debentures. Now, which kind of debenture, what type of debentures can be issued? So if I want to issue secured non-convertible debenture, irredeemable secured non-convertible debenture, it is not possible because the law is very clear that the debentures, the maximum periodicity of debenture is 10 years, and for infrastructure it is 30 years, and of course it is all subject to deposit rules. So secured non-convertible debentures, if it is redeemable, of course it is possible. Unsecured non-convertible, if it is irredeemable, not possible. If it is redeemable, of course, for listed, if those debentures are going to be listed as per the SEBI's regulation, then only possible. Otherwise, for unlisted, unsecured, non-convertible debenture, it is not possible. If it is secured, optionally convertible, again, redeemable is possible. Unsecured, optionally convertible, not possible. And secured, compulsory convertible debentures, it is possible. And but whether unsecured compulsory convertible debenture is possible or not, the answer is yes, it is possible, provided your convertibility period is 10 years, maximum for 10 years, because it is categorically mentioned in the deposit rules. So you have to make the compliance of deposit rules also. So this kind of debentures only can be issued. There are certain conditions which are given in the section itself, that such an issue of debenture shall be secured by creation of charge on the properties or assets of the companies, subsidiaries, holding company, or associate. Earlier it was only company was permitted. Now it is even the subsidiaries, holding company, and associate properties can also be charged while issuing of secured debentures, to make sure that the whatever assets are on which the charge is created having the sufficient value for the due repayment of the debenture as well as interest thereon. You have to make the appointment of trustees to execute the trust deed in form SS12, to create the charge on the specific movable property or specific immovable property only, which can be identifiable, and conditions relate to debenture trustees you need to comply with. Now, as far as these debenture trustees are concerned, these are the various there are various provisions with respect to duties and responsibilities of trustees, which are given in the rules, and in fact, who can be appointed trustees, that also mentioned in the rules. So there are certain qualifications of trustees are given, like or there are certain preconditions that those trustees should not have any kind of beneficial holdings in the shares of the companies. Then they should not those trustees cannot be the promoter, director, or KMP, or any other officer or an employee of the company, its holding subsidiary or associate. They should not be beneficially entitled to the money which are to be paid by the companies otherwise than on remuneration payable to the debenture trustee. There should not be any debt on debt to indebted to the company, its subsidiary holding associate. They if the trustee has furnished any kind of guarantee on the principal debt secured by the debenture or interest thereon, so of course they cannot become then the trustee. So there are certain preconditions which are we have to see with respect to the appointment of trustees, and there are certain duties are also prescribed as in of those appointed trustees. One of the duty, there are various duties, but the one of the important duty which we have to look at very carefully, that it shall the law says that it shall be the duty of the debenture trustee uh, to appoint a nominee director on the board of the company, to appoint nominee director on the board of the company in the event of the two consecutive defaults in the payment of interest to the debenture holders, or default in creation of security for debenture, or default in redemption of debenture. So there's a very important power you may say trustee will get, and not only the power, it is their duty also to appoint the nominee director on the board of the company if any of the three events occurred. So this again needs to have a very careful examination while executing the transactions with respect to issue of debentures. Section also talk about creation of this debenture redemption reserve. So these provisions were recently went two changes, two-time changes, and then the entire mechanism of maintenance of debenture redemption reserve. In what circumstance, what reserve, uh, and what type of companies and what kind of debentures are required to have this debenture redemption reserve is tabulated here. So you can of course go through this particular table for creation of debenture redemption reserve out of the profits of the company. But the another important provision, which the maintenance of this liquid asset, this debenture redemption reserve in the liquid form. So though the reserve I will be creating out of the profits of the company, which is available for the payment of dividend, but it says that the 15% of the amount of its debentures maturing during the year ending on 31st day of March of the next year shall be deposited or invested on or before 30th day of April each year for the purpose. So whatever is going to be matured of the so in 2020, what I will see on 31st of March 2020, I will see what is my outstanding liability as far as my of debenture is concerned, and out of which how much debentures are going to be redeemed in the financial year 2021. So 15% of that I need to maintain in the liquid form in deposit with any of the scheduled bank, free from any charge or lien, or I have to follow all, or there are other mechanism also provided where I can park all those funds in liquid form. Of course, this timeline for this particular year, uh, due to special reasons, because of this pandemic going on, is extended to 30th of September, but otherwise this limit as per the rules is 30th of day of April each year. So this is not required to be maintained by all classes of companies. It is required to be maintained by only limited classes of companies, which is prescribed in the rules. Now come to the buyback of securities. Again, going back to the section 179, which deals with the various powers to the board. And in this powers to the board, we have seen that the authority to buyback of securities under section 68 is again with the board. So board has to meet in and decide about the buyback. This particular authority also cannot be exercised by the board by way of resolution passed by circulation. It has to have in a board meeting of the company. Section 67 is there. So so relevant sections for dealing with buyback is 67, 68, and 69. 67 talks about that if any company limited by shares or guarantee and having share capital shall not have any power to buy its own share unless the consequent reduction of share capital is affected under the provisions of this act. So there is a complete prohibition in section 67 that you cannot have the buyback. Then it also says that no public company shall give directly or indirectly any kind of loan, guarantee, provision of security, or otherwise any kind of financial assistance for the purpose of or in connection with the purchase or subscription made or to be made by the person of or for any shares in the company. So no company can give any kind of financial assistance. The company's holding company cannot give any kind of financial assistance to purchase the shares of the company, nor I cannot have this buyback as per 62, 67 1. So then how to go for the buyback? So for that 68 is there. Now 68 is an overriding provision which says that notwithstanding anything contained in this act, so it is overriding 67 also. A company may purchase its own shares or other specified securities subject to provision of 68. So whatever is written in 68, you can, if you are following that, then there is no problem. Other than this, you cannot have buyback of your shares. So the section talks about buyback can be you can have it can be made out of free reserves, securities premium account, and the proceeds of the issue of the shares or other specified securities. And it also says that if you are going to have the buyback of, say, equity shares out of the proceeds or preference shares out of the proceeds of the same instrument, that cannot be done. So you have to make sure that any other kind of securities you can have. Then you have to have an authority for buying back of shares in articles. You have to pass a special resolution by the members of the company. But if your buyback is up to 10% of the share capital and free reserves, then no special resolution is required. Only board resolution is sufficient. Overall buyback, you can have 25%. Even with the special resolution, you cannot cross that limit. You need to make sure that after the buying back, your debt equity ratio should not be less than 2 is to should not be this more than this 2 is to 1. And you can have the fully paid up securities. Only whatever you're going to buy back, it should be fully paid up. For listed entities, you need to comply with the SEBI's buyback regulation 2018. That needs to be taken care of. And you need to also make sure that the 1 year has gone from the last buyback. And there are certain conditions which are prescribed in the rules. Now, so there are whatever the conditions prescribed, we will see that now. The important condition which is prescribed in the rules with regard to, again, disclosures to be made in the explanatory statement. A very long list of various disclosure is given, which start with the full and complete disclosure of all material facts, necessity, class of shares, amount, timelines, date of board meeting in which this proposal was approved, objective, class of shares or other securities intended to be purchased under the buyback, number of securities that the company proposes to buy back, the method, price, basis of arriving the price, maximum amount paid for the buyback and source of funds, the timelines, the aggregate shareholding of the promoter and directors, where the promoter is a company, and of the directors and KMP as on the date of the notice of the general meeting, aggregate post buyback, what will be the position, minimum price, maximum price. So there are so many disclosures are to be mentioned. Not only this, there is a confirmation is also required. There are certain confirmations which are required to be given in explanatory statement, like the company is not in having any subsisting default in repayment of deposit, interest payment thereon, redemption of debentures or payment of interest thereon, redemption of preference shares, payment of dividend due to any shareholder, or repayment of any term loan interest. So it cannot happen that you make the default of these people and go for the buyback. So first, if you have sufficient amount available with us to buying back of shares, so first clear their defaults. So you cannot have the subsisting default and go for the buyback. So you need to make sure of that. Then again, another confirmations are required by the board that they have made the full inquiry into the affairs and prospects of the company, and they form the opinion. So this is a confirmation by the board that immediately following the year on which the general meeting is convened, there shall be no ground on which the company could be found unable to pay its debts. So board has to make a very conscious call before making a buyback, that next 1 year the company should not found any kind of trouble with respect to payment of its debts. As regard to the prospects for the year immediately following the year, that having regard to the intentions with respect to the management of the company's business during that year, and the amount and the character of the financial resources which will be in their view be available for the company during the year, the company shall be able to meet its liabilities, and whenever those liabilities are going to be due for repayment, and it shall not render insolvent within a period of 1 year from that date. So that kind of undertaking is also required to be given by the directors. The directors will also say that they have taken into account the liabilities, including prospective and contingent, as if the company were being wound up under the provisions of Companies Act 2013. So these are the various confirmations which is to be given. Now, not only this, that the report which is addressed to the board of directors by the company's auditor is also going to be the part of your explanatory statement, which will say that they have inquired into the company's state of affairs. So this auditor will say, yes, whatever board is saying is correct, and they have inquired the amount of the permissible capital payment for the securities in question is in their view properly determined, that the audited accounts on the basis of which the calculation with respect to buyback is done is not more than 6 months old, or if it is more than 6 months old, then the limited review audited from the date of offer document. And the board of directors have formed the opinion on the reasonable ground that the company having regard to its favor shall not be rendered insolvent within a period of 1 year. So first, all this confirmation will be given by the directors in the explanatory statement, and also by the auditors of the company. Apart from that, there are certain other conditions which are required to be fulfilled, that the buyback shall be completed within a period of 1 year from the date of passing of the resolution, either by the shareholder, if it is up to 10%, by the members, by the board of the company. Then the letter of offer is going, whatever is to be prepared, it has to be in form SH8. Directors are also required to give a declaration of solvency, which is to be in form SH9. The letter of offer shall be dispatched to the shareholders immediately after the filing the same with the registrar of companies. So you have to make sure that the first you have to file it with the registrar, your SH8 along with SH9, you have to file with the registrar, and after filing with the registrar, you need to again then you need to dispatch it to all the shareholders of the company, or the security holders from you need to make the buyback. But the maximum time limit is again 21 days from its filing with the registrar. So that entire process of dispatching is to be completed within this particular timeline. The offer for the buyback shall remain open for a period of not less than 15 days and not exceeding 30 days, similar to right issue. Minimum is 15 days, maximum is 30 days from the date of dispatch of the letter of offer. And if it is agreed by all the members, then less than 15 days is also possible, but you need to get the consent from all the members of the company, which may be possible in case of closely held companies. But if it is a bigger companies having large number of shareholders, definitely this kind of consent to get this kind of consent is almost impossible. So because it is 100% consent, that too you have to receive in advance, then only you can have the less than 15 days timeline. After that, in case the number, whatever number you have decided that for the buying back of the shares or the specified securities, if you have received the application for the more number of shares, then you can have the buyback on the proportionate basis also. And the company needs to complete the verification of all the offers received within 15 days from the closure of the offer. So whenever I have received the offer, my offer, that offer for this buyback, my letter of offer has gone to the shareholder, I have received it back, then my offer is closed. Once it is closed, within 15 days from the closure, I need to verify uh, the documentation, and if no communication of rejection is made to the shareholder, it will be deemed that I have accepted that offer within a within a period of 21 days from the date of closure of the offer. So you have to complete the process of verification as well as send the communication in case of rejection. And if it is not made, then it will be deemed that you have accepted this offer for buyback. Then the section also prescribe, rather a rule also prescribe that the company shall immediately after the date of closure of offer open a separate bank account and deposit therein such sum as would, whatever the sum which is required to be paid to the shareholders or the securities holder, which will be towards the consideration for the shares which they have tendered in the buyback. So that particular amount is to be deposited in this separate bank account, and within 7 days you need to make the consideration payment in consideration in cash to those shareholders whose applications you have accepted for buying back, or you need to return the share certificate to the shareholder, because once if it is if the shareholders are holding physical shares, and I assuming that the mandatory demat is not applicable to them, then they are tendering back the certificates to me, and I've rejected the application. So what I need to do, I need to send back the share certificate to those shareholders if the offer is not accepted, or if it is accepted, then I need to make the payments from that separate account which is open in this regard. The letter of offer shall contain true, factual, and material information and shall not contain any misleading information, and must state that the directors of the company accept the responsibility for the information contained in such documents. So whatever the responsibilities pertaining to any information is there, it has to be, entire responsibility is with the directors of the company. The companies shall not issue any new shares, including by way of bonus, from the date of passing of a special resolution authorizing the buyback till the date of closure of the offer under these rules, except those arising out of any outstanding convertible instrument. So if you have any outstanding obligation, which because of which you need to convert certain shares, that you can definitely go for. Otherwise, you cannot issue any kind of new shares. The company shall also confirm in its offer document the opening of a separate bank account. The company shall not withdraw the offer once made. So you have to be very careful. Once you have made the offer, you don't have any choice but to go with the offer. You cannot withdraw it back. Then also the company shall not utilize the money borrowed from the bank. So you cannot have the money borrowed from the bank and then utilize it for the purpose of buying back the shares. So whatever the buying back is to be done, it is to be done from your own sources, not from bank or financial institutions. The company shall not utilize the proceeds of an earlier issue of the same kind of shares or the same kind of other specified securities for the buyback, which I've already explained some time back. And the securities are to be physically extinguished within 7 days. Then no same kind of securities can be issued within a period of 12 months, except bonus obligation shares arising out of conversion sweat equity. Now, what we have read earlier, that if your issue is open and if it is presently going on, during that time you cannot issue even bonus shares. But once the entire buyback process is completed. So of course, within a period of 12 months, you cannot issue the same kind of securities. But after closure of the after completion of the buyback process, even within 12 months, you can go for bonus issue. That's not a there is no bar on issue of bonus shares, and the return is required to be filed in Form SH11 along with Form SH15 after when the buyback process is completed. So this return is also required to be filed. In Form SH10, company needs to maintain a complete register of the shares or other securities which have been bought back. This register meant to be maintained at the registered office of the company, in the custody of the secretary of the company or any other person authorized by the board. Entries has to be authenticated by the authorized person or the secretary of the company, where the company has purchased this securities out of free reserves or the securities premium account. So this is the provision of section 68, which says that whenever you are using the proceeds of this buyback from your free reserves or securities premium account, then a sum equal to the nominal value of the shares so purchased shall be transferred to the CRR, that is Capital Redemption Reserve account, and the disclosure is required to be made in the board's report. Sorry, in the balance sheet. I'm so sorry. In the balance sheets of the company that you've created this reserve, and this reserve, the CRR, may be applied by the company in paying up unissued shares of the company to be issued to the members of the company as fully paid up bonus shares. So how you can utilize this? You can utilize it for the purpose of issuance of fully paid bonus shares to the members of the company. Can you do the buyback by way of a scheme of arrangements? We have some of the instances where the shares were bought back as part of the scheme of arrangement. So under the old act, there was no such prohibition per se, though there is a provision under section 77A for buying back of the shares, but there is no prohibition that you cannot go for the scheme route for buying back of the shares. But in the current law, section 230 is there, which says that no compromise or arrangement in respect of any buyback of securities under this section shall be sanctioned by the tribunal unless such buyback is in accordance with the provision of section 68. So you can have it, the buyback proposal, as part of your scheme. However, you have to make sure that whatever is mentioned in section 68, you are also complying in that scheme route as well. So by doing this, you can of course have the scheme route available for this. Otherwise, if you just going to the tribunal for the sanctioning of the buyback by way of a scheme of arrangement without having complying of section 68, then surely tribunal cannot sanction such kind of scheme of arrangements. So this is also to be seen. Now, so we have dealt with issue of securities by various modes, buying back of shares. We have dealt with preference shares. We have dealt with debentures. Now, this is another important aspects which you need to take care before issuance of securities, because these are the possible impacts on compliances which you need to keep in mind while issuance. What are the possible impacts when you issue any kind of capital? So there is an impact on the first impact on the criteria based provision, especially which is linked to the capital and net worth. So say for example, I am issuing share capital, and my presently my capital is say 45 crore, right? And assuming that my net worth, assume my net worth is say 450 crore. Now I came with a issue of shares, say of 100 crore. So suddenly what has happened, my capital has from 45 crores to become 145 crore. And my, so what will be the impact? So impact would be, since my capital is crossed 50 crore limit and 100 crore limit. So I need to look at that what are the criteria based provisions which are applicable to me for the 50 crore limit and for the 100 crore limit. Say for example, annual return certification, which may come into, this is a secretarial audit, which may come into picture, appointment of woman director may come into picture. And as I had given the example where I said the 4,450 crore is suppose my net worth. So suddenly what will happen, my net worth, because in net worth paid up capital is also to be considered, and suddenly my net worth has also crossed to 500 crore, so CSR provision will become applicable. So all this criteria based provision analysis is to be done upfront. I understand that there are a lot of provisions which are applicable based on the last audited financial statement. So you may say so that I need not to bother about my capital issue, which I'm going to make in the month of say July, August, September and all, because as per last audited financial statement, it is not applicable to me. But it's still an analysis is to be done. A careful analysis is to be done. So the moment it has become applicable to you, immediately you are in a position to comply with those provisions, or at least you can make suitable provisions for complying those provisions. There is another important aspect with regard to change in the relationships, because there is a possibility that you have issued the shares to on a private placement basis, and because of which uh, somebody has subscribed, some company has subscribed your shares to the extent of say 20%. So earlier you are not associate company of that company, now you have become the associate company. So you need to look at that aspect. Similarly, you may become a subsidiary of some company, you may become, your holding company may gets changed because of if some other company on private placement basis, if you are issuing the shares and the identified party is and because of that there is a change in control, or if there is no change in control within the same group also, there is a possibility your holding company may get changed. So all those scenarios you have to take into account even before issuance of the capital itself. There is another possibility that your related parties relationships may get changed, or certain new related party may come into picture. uh, like as I said, you may become the associate of someone. So the moment the new party is coming into picture and you are the associate of that new party, so definitely that new party will also become your related party. So you need to take care that, and this provision will become immediately applicable. And suppose you are doing some kind of transaction with them, so you need to make sure that the moment it has become your related party, you should have suitable approvals for the related party transactions. Uh, if not, if section 188 is not applicable, so and if audit committee is applicable, so you should have those approvals in place. At least you should be aware of this thing, whether it is become applicable, not applicable, whether section will become applicable or not, all those things are secondary, but at least you should be aware of this particular aspect before itself, that there are because these are the critical provisions. This may lead to another kind of trouble if any kind of non-compliances are done in this regard. And of course, another important provision which just came in my mind, this significant beneficial ownership. So if somebody is subscribing your 10% of capital, then SBO, then you need to look at the entire chain, that who say company is having subscribed 10% of capital in your company. So you need to see that who are the individual behind that company. You need to look at the person who is holding more than 50% or the majority stake in that company which is subscribed in your company. So accordingly, that individual who is holding majority stake will become significant beneficial owner of your company. If the company is having another holding company, so you need to check who is the person holding majority stake in that company. So that individual will become your significant beneficial owner. So accordingly, all those uh, provisions you need to look into it. Then disclosure since board's report as per Secretarial Standard 4, you need to disclose in your board's report whatever capital you have issued during the year, the mode of capital, whether it is at par, premium, various disclosures which are prescribed over there, you need to disclose that. You need to have MGT 9 and MGT 7, your annual return and extract of annual return. You need to make the disclosure about change in capital structure. So whatever the new capital is issued, or if it is bought back, so suitable disclosures are required to be made. In MGT 9 and 10 also, there is a possibility your top 10 shareholders may get changed, your promoter may change, your holding subsidiary, your holding company may change. So all those things are to be taken care while making a disclosure in the board's report and form MGT 9 and MGT 7. Also, disclosure in financial statement as per Schedule 3, whatever the capital raising you are having during the year, you need to have a separate disclosure with regard to them. And also, if any of the shareholder is holding more than 5% of the capital, a separate entry, a separate disclosure with the name of the shareholder should come. So any kind of changes which are happening because of the issue of capital, so your disclosure in financial statement may also needs to be suitably relooked. It cannot be just a simple copy paste exercise from the last year. You have to see that if any capital is issued during the year, accordingly you have to make the disclosure as per Schedule 3. Then, of course, disclosure as per CARO 2020. So this I think there was a separate session already there on this particular aspect. So I'm not going into the details of this. So as per CARO 2020, whatever disclosures are required to be made, it is also to be taken care of. Yeah, then another provision with regard to your various limits like borrowing, etc. Because there are certain limits which are based on your capital. So a company can borrow the money up to the paid up capital plus free reserves plus securities premium account. So accordingly, these limits may change for borrowing of the money and all. So you need to take care of this aspect as well. Then preference shares vis-a-vis voting rights. This is another important concept because Section 48 of the Companies Act 2013 deals with the voting rights on the preference shares. It says that the preference shareholder have a right to vote on the matters related to preference shares. So they may vote in those resolutions. But however, the section also says that in case any in case the dividend is not paid to the preference shareholders for a period of 2 years, then they will get right to vote on all the resolution of the company. So this is a very important provision because so while making the planning of issuance of the capital, you need to keep this particular aspect as well. And this aspect is very important from another angle because of the definition of holding definition of subsidiary company, because it is linked with the not with the paid up capital of the company, it is linked with the voting rights. So if suppose you have issued your equity capital is 100 rupees today, which is held by say A Limited, and you have a preference share capital of 200 rupees which is held by say B Limited, and so as and preference shares, whatever preference shares you have issued, on which 2 years has not gone yet. So today you are the wholly owned subsidiary of A Limited. Now what will happen the moment 2 years have gone after issuance of the after allotment of the preference shares, 2 years have gone and you have not paid the dividend on those preference shares. So what will happen? The B Limited will get the rights to vote on all the resolution. So accordingly, your total voting capital from will become from 100 to 300, and out of 300, 200 is held by B Limited. So accordingly, the B Limited will become suddenly your holding company, and you cease to be wholly owned subsidiary, and you will become the subsidiary of B Limited. So all these aspects are also to be seen while planning of issuance of capital. Then another part is with regard to deposit rules. So you have to take care of various disclosure, which is first is the compliance of the 60 days time limit for allotment of shares from the receipt of the subscription amount. So rule says that if you have allotted, if you have received the subscription money, then you need to allot the shares within a period of 60 days from the date of receipt of that subscription money. If it is not possible, if you're not allotted, then in next 15 days you need to refund with interest. And if still you can't do that, then from 76th day onwards it will become deposit. So that is also an important aspect. You may violate the provision of deposit. I think Mr. Trupal has made an excellent presentation on explaining various headings of the definition of deposit. So I'm not going into the details of that. So this is one aspect. The another aspect is, suppose you have issued the capital in the month of, say, towards the end of the financial year, say in the month of March, say on 15th of March, you have issued the shares and you receive the subscription money, say on 25th of March. And you have not allotted the shares against that subscription money, and you have completed the allotment in the month of April. So within 60 days you have completed. So there is no non-compliance with regard to that. But on 31st of March, this amount was there in your books as a subscription amount, not as a share capital. So accordingly, in return of deposit, which is to be filed by 30th of June every year, you need to make this disclosure that you have a subscription amount lying with you, which is yet to be, against which the shares are yet to be allotted. Because as on 31st of March, it was pending to be allotted. So that disclosure is required to be made in your DPT3 return. So such kind of provisions, these are the various different, there may be other provisions also, but I thought to speak about few of the important provision which may impact your planning as far as capital raising is concerned. With this, I'm through with the my presentation part. If we have any specific question, we can deal with that. And as I already mentioned before that, I will not deal with any company specific or any person specific questions.
Thank you, Anshul, for such an excellent presentation and deliberation from all the aspects of the issue of the securities. Anshul, I know you have some pre-scheduled meeting. Can you confirm how much time we have? Because we have got more than 100 questions.
I'm extremely sorry, I may not be able to deal with all the 100 questions because of the time issue, and we lost certain time in between because of technical reasons. Of course, we can spend about 10 minutes for some of the important questions.
So participants, just a small announcement that I'm going to make. Let me just share. If you are able to share, see this screen, Anshul.
Yes, sir, yes, sir.
Yes, I'm able to see this.
Tell us that if it is feasible.
Okay, so the participants, we have one very special master class on Saturday, July 11th. That is the last day of our master class. And we have none other than Honorable Justice Markandeya Katju to address us on the issues of interpretation of statute with a specific reference to the Mimamsa principles. So we look forward. The link remains same and everything remains same. That was just a intimation to all of you. I'll be sharing the screen for. Anshul, can you see this screen?
Yeah.
Okay. Sheetal, can shares issued under right issue be renounced in favor of third person who is not a member of the company?
I've already, I think, addressed this. Yes, you can do that, but you need to again go with your intentions also, and keeping in mind with the that judgment which I've shared that time. So
Yeah.
of course it can be done subject to articles of the company.
Bhumika is asking what exactly do we mean by derivatives?
Of course, it's a market instrument, nothing to do with the issuance of security. It's a instrument where the underlying is your shares, and it's a instrument which is traded in the market and settled in the cash. There is no physical delivery as far as securities are concerned, and you can have future trading, you can have trading in option and options trading, which may be put options, which may be call options. So itself a subject, but as far as companies per se is concerned, there is no concept of issuance of derivatives by the company.
Yeah. What is the scripts? Can you please explain? I believe.
So
Yeah.
it's a general terminology. We use the shares and the scripts interchangeably.
Kailash is asking, can you please elaborate stamp duty introduced on offline transfer of demat shares and rate thereof?
Uh, so as far as offline demat transfer is concerned, so before making the transfer to any uh, means to the other party, first you need to make sure that you have paid the stamp duty on that particular transfer. I'm sorry, I'm not ready with the stamp duty rate, which is just recently prescribed.
1st July, so
Yeah,
one
it
need
is.
to check into the schedule and then only.
Yes. So depositories, since it is off-market transfer of demat shares, so you need to go to the depositories website. So they have given the suitable web page is there where you need to select the option for uh, transfer of shares, and accordingly you need to put some of the data: who is the transfer, who is the transferee, what is the rates and everything. Once everything is filled up, the system will give you the stamp duty, and you can pay via your net banking channel or any other mode of payment available over there.
Anshul, I think you have dealt this next question also in detail. What is the
Yeah.
difference between the private placement and preferential allotment? But I will request, because this has been repeated at least 10 times in this query sheet. So I think once you clarify, then again it will be better.
Uh, as far as this as I mentioned, that the whenever you are issuing shares, you have very limited processes. You have limited methodologies by which you can issue the shares. One is you can go with the right issue. If you are a private company, you can go with the private placement, and you can go with the bonus issues. Or if you are a public company, of course, you have option to go into the public as well. So uh, so this preferential offer, issuance of shares by preferential on preferential basis, which is given in 62(1)(c), is not a methodology for issuance of the shares. It is more from it is add-on processes, and there are certain more disclosure which are required to be made if you are falling in 1662(1)(c). And in section 62(1)(c), you need to look at uh, one thing, that which kind of security you are issuing. If you are issuing any kind of shares or any other kind of securities which is convertible into shares, uh, then then you need to follow 62(1)(c) also. If it is a security which is not going to be converted in shares, like the example of, say, redeemable preference shares, which is not going to be converted into equity shares, so then you need not to worry about 62(1)(c). Then only follow 42, read with 55, and you're, yeah. So preferential, this issuance of share on preferential basis is an add-on process. It is not a methodology. It's an add-on process which you need to comply with.
Yeah, thank you, Anshul. What is the scope of Section 62(3)? Does it mean that loan can never be converted into cash, or it can be by adhering to the Regulation 62(1)?
You can, if it is preconditions, because Section 62, I think, start with nothing contained in this section shall apply. So, of course, you need to read it independently. And if it is while giving up the loan, if it is a precondition about the conversion and all, which is also passed by the members by way of special resolution, then it can be converted.
Neeraj is asking, sir, in case of company issues right shares and 30% of the shareholders are holders of shares in physical form, then the shareholders are entitled to receive the right issue benefit. I believe he's talking about unlisted public company.
Yeah, I understand that, but unfortunately, there is no such mechanism is available as far as present Rule 9A is concerned. I am interpreting it conservatively that we cannot go ahead with the making the allotment of shares to such holders.
All right. Kishore is asking under Rule 9A whether wholly owned subsidiary means unlisted public company and includes wholly owned subsidiary private limited company. Wholly owned subsidiary of public will always be a public limited only. So I believe it is self-answered. Neeraj is asking if a company issues share through ESOP allotment, but due to some issue, the company transfer the share in demat account of employee in more than 3 months. Then any implication or failure?
So, I'm assuming that the allotment process is completed. Only the shares has not been transferred to the demat account of the shareholders. I think the maximum time limit is given in the law within which you need to complete this demat credit or issuance of share certificate, whatever is applicable to you. And if it is not compliant, then there is definitely penal action may follow.
Sandeep is asking when government company have got the exemption for mandatory demat as per Rule 9A, does it include shares of public sector companies, for example, banks like State Bank of India? Will it have to keep the physical shares? I believe
So,
it will not be limited.
just to quickly answer that, the SBI is a listed body corporate and provision of LODR and SEBI applicable to it. So,
In any case, they have to keep the shares in demat only.
yes.
Jyotsna is asking how to treat sweat equity, how to issue sweat equity, and if it is to be issued to employee, then what could be the accounting entry?
So,
Sweat equity, I believe, as the name suggests, it has to come or earned out of the sweat of the employee. So you can throw some more light, Anshul.
actually, this itself is a process and itself is a concept for issuance of the sweat equity shares. Uh, I am, if you can excuse me because of the time issue, and
Asking, yeah, all right, Anshul. I believe.
as far as accounting treatment is concerned, a normal accounting entry whenever you receive the money and credit your capital account, that can be passed. There is no.
The accounting treatment is more like a ESOP only. You have to charge it to the profit and loss account of the respective year in which you are granting that option or issuing that security. And the process also remains more or less the same.
Yeah.
In case of unlisted public company, if any one of the shareholder dies, then transmission can be done in physical mode. Yes. Darshan is asking Section 23 provides that private company may issue securities through right issue. However, Section 62 uses the word shares. Can private company issue convertible security through right issue? I believe you dealt.
Yeah.
You want to clarify something? You can please.
Section 62(1) uses the word share. 62(1)(a) uses the shares. 62(1)(c) uses the securities. So, so definitely by following 62(1)(c), read with 42, you can have the you can issue the convertible securities.
Is it compulsory to get the valuation done when issuing shares to the subscriber and promoters of a private limited company?
So if you are covered by 42, read with 62(1)(c), of course you have to go for the valuation for to issue the shares to any person. There is nothing like that subscriber or promoter. If you're it is if you are
No
going
such privilege is available to any person, whether you are a promoter or
yes,
subscriber. If you are issuing on the basis of preferential allotment or private placement, you have to follow the valuation norms. Rekha is asking what is meant by marketable security in the definition of securities.
so marketable securities means which is available for trading in the market, as the name suggests.
Yeah.
And so any securities which can be tradable in the market, and any of the like nature, if any other instrument which is also having the capability of trading in the market, then those will be covered in the definition of securities.
Yeah. A newly formed unlisted public company can issue shares to subscriber in physical form, or it should be in demat form only.
Initially you can have physical form, this capital, but of course you need to take care whenever you are issuing the shares in future of any kind of securities. You need to ensure that you get them or you obtain the ISIN for your securities and get them converted into dematerialized form.
I believe Karthik's question is very long. He's asking, trying to understand whether LLP can do the business of NBFC. I believe that is specifically prohibited. That cannot be done. Leaving the long question, please explain about ISIN and also why companies cannot have more than 17 ISIN. Shul, can you explain?
Uh, as far as ISIN part is concerned, this is nothing but the a specific alphanumeric number given to your securities. And in this alphanumeric number, also the digit 4 to 7 is your issuer code, which is unique to you. For all your ISIN, you will have the common 4 to 7 number, and remaining depends upon the kind of securities, and some unique numbers are assigned to all your securities. So, and I'm also clubbing the next question, how to obtain it. So, of course, you have to go to the depositories. You have to first appoint a registrar, and also make a tripartite agreement with the depositories, either NSDL or CDSL, or both. You can have both also. And uh, then you have to apply for issuance of ISIN, and thereafter you can get converted your securities into dematerialized form.
Shares must be converted into equity share if no agreement has been executed. Conversion of unsecured loan into security, into the equity. 20 number.
Yeah, so as we have already seen that if it is precondition uh, of this conversion, I think this question was already dealt before 62(3). If you are able to comply with that provision, then of course you can do that.
Yeah, even otherwise also it can be done. It can be considered purely as a consideration in cash only. There is no difficulty.
Yeah, it will definitely, it will be termed as a consideration in cash.
If a company makes allotment of shares and subsequently come to know that one of the shareholders do not have a demat account, what action company has to take in this situation?
So first of all, before allotment, when you have accepted the application, then that is why I mentioned specifically that you should also obtain the proof of demat account of the shareholder along with the application, so you are very sure that that person has the demat account available. Not only this, even the depositories are also having a facility whereby you can before making the allotment, you can check whether this demat account belongs to whom. So before going for the final corporate action, you should get it verified by the depositories and then only make the allotment.
Anshul, do you suggest filing of GNL2 is as PS6 is not available? I believe MCA itself has denied that.
Yes, MC has already, I think, given a clarification in this regard, so no need to go ahead with filing of GNL2 as of now.
I think this Nilesh question was answered. If a company file PS3 on 15th day of allotment and use the fund within 24 hours of allotment, which will be termed as default. I believe you clarified not only allotment, you have to file the PS3, and as soon as the PS3 is filed,
And both
you can.
both the processes should be completed within means this PAS3. So once you allot the shares within 15 days, you have to file the PAS3, and then only you can allot the you can utilize the money.
Unless you file, you cannot use
You
the
cannot
money.
utilize.
Once
Yes.
you file, then there is no time limit. In a second time, you can use the complete money. Rajesh is asking, this I think we have answered. Prashant is asking, is it mandatory to get the securities valued? I think registered valuer aspect we have
Yes.
clarified. Companies
Registered value.
247 is very clear. You have to get the valuation report from the registered valuer, who may be a chartered accountant also if he is registered as a valuer. Shalini, in case of companies having equity shares and would like to issue preference shares, can they issue preference share on right basis and renounce the same to some outsiders?
Yes, possible. Uh, Legally, of course, it is possible. No issue with that. But whatever the risk associated with it, I've already clarified that. You can within that framework, and you can do that.
Yeah, nationalized bank, all we have discussed. What is the difference between the information memorandum and PS4? I think this is also discussed. Whether filing, this has also been done. What is the validity period of the valuation report? I believe, Anshul, this question cannot be answered straight away because there is no period prescribed in the valuation report.
I feel so that the purpose for which the valuation report is sought, uh, and we have to also work around the reasonability factors. My board has decided, said today, for going ahead with the issuance of shares on private placement, but actual execution is going to happen, say, after 8 months of time. So then of course it is unfair to say that I will use that particular valuation report because there may be some circumstantial change which may happen. So
Absolutely. I
reasonability.
think it will be decided on case basis more.
Basis, yes.
If your valuation are likely to be impacted due to any changes during that period, then you have to take a fresh valuation. Otherwise, it would be correct. This is what we have done. A lot of repeated questions are there. Can all the amount in case of a right issue be issued in advance and some way issue and allotment can be done in a single board meeting for right issue?
Can all the amounts in case of right issue be issued in advance? I'm not able to understand the exact question.
No, it cannot be done. I believe the person is asking that I receive the money whenever I want and later on I issue the offer letter and convert that money received into, because you may be caught into the provisions of the deposit rules.
Deposit rules.
Can a company issue shares to the same NRI on both repatriation and non-repatriation basis?
So whatever the guidelines under foreign exchange are permitting, you have to look at the sectors and all those things. Cannot be answered straightforward.
I believe Neeraj question you have answered 15 days provision. Changes also has been discussed. If the member renunciate the right in the right issue to any of other person other than the existing member, then will that be considered as violation of condition? I think you answered this question also. If a preferential allotment always made to the resident outside India or foreign securities, whereas private placement can be done, no, I believe that understanding is not correct. Is there any need to amend the article of association for issue of the private placement or preferential allotment?
You should have that necessary power available in your articles of association, specifically mentioned in the rules. If it is there, no problem. If not there, then of course you have to have article amended.
Rajesh is asking for conversion of CCPS to equity. Should the equity authorized capital be increased before such conversion? Obviously, yes. There is no
Obviously,
doubt
yes.
about that. The company cannot directly issue securities under 62(1)(c). I don't know what it means directly issue securities under. Yeah, by passing a special resolution, the company can issue. Whether partly convertible debentures can be redeemed in full means redemption of debenture at premium, or the debenture can be redeemed when they are partly paid.
Actually, my screen is not moving, so I'm not able to see where's the question.
Yeah, I believe her question is that whether partly convertible debentures can be redeemed in full, although I'm not able to understand. We need to understand what is the meaning of redemption in full, whether it is indicating to the payment of premium or what. Can share premium account be used to write off losses and pay dividend after such write-off?
There are specific provision how you can utilize securities premium account, and of course this you can do by way of scheme of arrangement, but not directly without having any scheme also.
A lot of repeated questions are there. So just skip. Whether partly convertible debentures can be redeemed in full? Again, the same question.
The same question, I think it is not given to us.
If it is a mixture of right issue and the private placement of equity share, then it has to be done as per preferential offer method.
So I believe the question is we are also issuing to the existing shareholders as well as to the some identified person. So in your identified person, your existing shareholder will also come, and accordingly you can go. But mixture of right issue means you are issuing to all the shareholders without specifying, without identifying the person. It looks a bit difficult. But some of the existing shareholders and some of the outsider, of course, you can do that.
So Hans is asking as part of term of conversion, part of terms of loan provided to the company, the financial institution has converted part loan into equity. At what price such conversion is allowed? I believe it has to go with the terms of
Yeah.
loan that has been accorded. Basis that only the conversion will happen. What kind of penalty can be levied in case company fails to keep at least 15% of the amount that is provided in the section 71? How the buyback price is arrived? I believe for unlisted companies there is no mechanism
No
provided.
mechanism is provided, only the valuation is to be done. And for listed company, of course, there are different methodologies.
Leave buyback of the repeated questions. A public limited company wants to issue and allot unsecured non-convertible debentures to a single person to a private company for an amount of rupees 30 crore. The issuer company passed a resolution under section 181(c) in the year 2016 to increase its borrowing limit. I believe you addressed this issue. you can re-clarify that 42, the new section that was replaced, is providing that if you are issuing the non-convertible debenture, then you need not follow the specific process as long as you are borrowing, your debenture issue is within the limit of the borrowing power. I think rest are all repeated questions. So with this, we can conclude the today's session. Thank you so much, Anshul, for answering all the queries. Most of them were related to the issue of security, and many of them were repeated. So thanks to you for patiently answering all the questions and explaining the concept of issue of securities in such a nice manner. I will request Sudhanshu ji to say the concluding remarks, and then we can wind up the session for the day.
Thank you, sir. It was indeed very informative, and we got to know there are many things, many clarifications that I also required with multiple provisions that you clarified, whether it's with respect to debentures and especially the entire explanation about requirement about dematerialization of shares. So I think the students must have gained quite a lot with all this information. Obviously, they need to go back and brush up their company law provisions and rules. But I thank you, sir. Again, it was indeed very informative for me as well.
Yes, thank you very much. And of course, I would look forward to go through some of the or learn from your research also in time to come.
Sure, sir. Sure, sir. Thank you very much.
Thank you very much.
Thank you. I believe Dr. Vishalakshi is also there. Ma'am, if you are there, then you may say few words and we can close. I believe she is not there. Anyways, on behalf of Dr. Manohar, Lohiya, National Law University, I extend my gratitude to Professor Sudhakar from Nalsar University of Law for sparing his valuable time. That's too early in the morning. I know his online classes are on now, and he has to attend the classes, take the classes for the student as well. I'll not take much time. And thanks to Anshul ji for sparing valuable time. And that's too on a working day, early in the morning. I know again your office has already started, and you have to take care of your meetings and all. So thanks to both of these panelists for being with us and imparting us with so important knowledge on the corporate law regarding the issuance of security, which is considered to be the blood of any business organization. I'm sure the knowledge that has been imparted and the clarifications that have been provided by the panelists today will be useful in your career and your future endeavors. Again, I am announcing that on 11th of July, that is the 15th day of our masterclass, we are going to have a special masterclass wherein Honorable Justice Katju is going to address us on the issues of interpretation with a special reference to the Mimamsa principle. Tomorrow we are going to have a special session on annual report and the board report and annual return contents and all. Mr. G.P. Madan is going to take that session. Details are already shared on your email ID. Thank you so much. Look forward to meet you tomorrow morning again at 7 a.m. Thank you.
Sir.
Thank you.